When people look at a contract, they often assume that every clause present in that contract carries the same weight. That isn't how contracts work. In reality, not all parts of a contract carry or have the same weight. Some clauses sit in the background quietly, while others decide the outcome when or the moment something goes wrong. So, in order to understand disputes, you must first understand the structure of a contract, not the formatting, not the length or the page count, but where the real weight of a contract actually lies. When we talk about the structure of a contract, we are not talking about formatting, numbering, or how neatly it is laid out. Structure is about how decisions are organized inside the contract. It is the order in which the contract answers questions when something goes wrong. When there is a problem, no one reads a contract from the page 1. They jump straight to the clauses that decide survival. Think about what happens when a problem arises, like a payment is delayed, performance is questioned, termination is threatened. At that point, people move straight to the payment clause to see what was due, then to the default or termination clause to see what can be done next, and very quickly to the dispute resolution clause to see where this is heading. Those clauses suddenly matter more than everything else. That order, which clause is reached first, which clause limits the next, and which clause ultimately decides the outcome is the structure of the contract. That is the hierarchy. When everything is running smoothly, this hierarchy remains hidden. No one checks which clause overrides other. No one asks what survives termination, and no one checks about where disputes will be heard. But when things slip or stall, this hierarchy reveals itself, and you suddenly realize that some clauses carry the contract through this conflict, while others, though carefully drafted, stop mattering at that time. This difference is not accidental, it is structural. Every contract focuses on two different levels. The first layer is what most people naturally focus on. That is the commercial terms. This is where you find things like what is being supplied or delivered, how much is being paid, when performance is expected, and how milestones are structured. These are the clauses that dominate discussions at the beginning. They explain the deal. They reflect the business understanding. During negotiations also, this is where most of the energy goes. But beneath those terms, there sits a second layer, the legal backbone of the contract. This layer usually includes clauses on termination, dispute resolution, governing law and jurisdiction, limitation of liability, and survival of the obligations. These clauses don't explain the deal. They control what happens when the deal stops working. They decide who has the power when things break down, who gets to decide the next steps, where disputes are taken, and how much damage can realistically be claimed. During negotiation, this layer feels distant. Sometimes they are rushed, sometimes they are copied, and sometimes they are barely discussed between the parties. But once dispute arises, the attention shifts completely. Commercial terms fade into the background and the legal backbone takes over. This shift often surprises people, not because these clauses were hidden, but because these clauses were never treated as decisive. Some clauses appear unimportant because they do very little when things are working between the parties. Like, you don't think about the jurisdiction when the payments are on time. You don't look at dispute resolution when the parties are cooperating. Similarly, you don't worry about limitation of liability when there is trust between the parties. But the moment that trust breaks, these clauses step forward. They don't manage the performance of the contract, they manage the conflict. That is why these clauses often decide the outcome, even though they were barely discussed at the time of signing the contract. Understanding this difference is critical. Otherwise, you will end up over-investing in clauses that explain the deal and under-investing in the clauses that control the fallout. When dispute reaches court or arbitration, the contract is no longer read casually. It is relied upon. At that stage, formatting, heading, or the length of the contract does not matter. What matters is how the contract holds together under pressure. Attention naturally shifts or creates certain questions. Where the rights are created in the contract, where discretion is allowed, where consequences are fixed, and where authority has been assigned. These are not stylistic details. They determine how much room is there to argue. A contract that looks polished but answers these questions poorly often provides very little protection. On the other hand, a contract that looks simple but answers these questions clearly often performs much better when it's tested under pressure. This is the reason why structure matters more than presentation. This lesson establishes an important shift to how you look at contracts. A contract is not a flat document where every clause works in the same way. Instead, a contract is a layered document where some clauses explain the relationship between the parties, while others control what happens when that relationship breaks. Without this distinction, contracts often feel understood until a dispute shows otherwise. Once you accept that not all clauses in a contract carry the same weight, the next question becomes unavoidable. Which clauses actually determine when things go wrong between the parties, right? So, in the next lesson, we will look at a small set of clauses that actually determine everything during disputes and why their importance is actually realized far too late. Thank you.